Leisek has fired his old attorney. He's gotten 2 new attorneys, and the DA isn't notifying the victim of these court date changes. Let's get into it. Hey everyone, Empowering True Crime, Alex here. There was actually a document that was filed by Jared Leisek's new attorneys. So the really interesting thing is that his court date was actually yesterday, April 19th. I put out a video on Tuesday, the 18th, just as a reminder about the court date. I put it out in the afternoon, and by the morning, we were already noticing that the court had changed. It was no longer a preliminary hearing, and instead it was a scheduling conference. And we noticed that there were 2 new attorneys, 2 new names on there as the attorneys for Jared Leisek. So I got confirmation on that. And then SF posted this document, this legal document, which we're going to go over in just a second. He posted it on Twitter. So shout out to him. He always finds and shares documents in this case. So a lot of the information I've gotten as far as documents, legal documents, have been from him. So shout out to SF Investigates. All right. So Kara M. Tangaro and Scott C. Williams, both from Salt Lake City, Utah. And it says in the 6th District Court of Manti Innan for Sanpete County, state of Utah. This is a request for discovery in the state of Utah versus Jared Leisek. Comes now, the defendant by and through his attorneys of record, pursuant to the provisions of Rule 16, Utah Rules of Criminal Procedure, and the Due Process Clauses of the United States Constitution, and of the Utah Constitution, the following requests for discovery are specifically addressed to the police prosecution investigation team. Okay, so they're asking for discovery. What is discovery? Discovery is like all of the information, the data, the documents, the evidence that the state has acquired. And the state, as it says here, addressed to the police, prosecution, and investigation team. So the police and the investigating team are part of that entire bucket of the prosecution and the state. Okay? So the following requests for discovery are being made. Number 1, all written or recorded statements of the defendant or co-defendants. Number 2, the substance of an oral statement made by the defendant, which the prosecution intends to offer into evidence, which was made before or after arrest to any person then known to the defendant to be a government agent. Number 3, the criminal and driving record of the defendant. Number 4, the criminal record of any material witness whose testimony the prosecution intends to present at any hearing or trial. Number 5, all physical evidence seized in the investigation of the alleged offenses, including the results of any scientific analysis of any and all evidence seized for the purpose of the prosecution of this case. Number 6, any and all video or audio recordings and other electronic communication or documentation of any kind relating to the incident, such as dispatch logs, transmissions or recordings, email communications, or any other electronic data, including communications between law enforcement agents or agencies and communications between agents and potential witnesses. Number 7, all written reports, statements, and any other documentation relating to the investigation of the allegations herein, including copies of search warrants, affidavits for search warrants, search warrant returns, copies of administrative subpoenas and supporting affidavits, secrecy orders, and any other police reports or prosecution reports in the possession of the police, prosecution, and investigation team. Number 8, with specific regard to any warrant issued in the case, any notes, data, time logs, transmissions, email communications, email time indications, drafts, and any other evidence or documentation of any kind between the affiant of the search warrant affidavit and A, any person the affiant relies on in making factual averments in the affidavit, B, any prosecutor reviewing the affidavit in support of the warrant, and C, the authorizing court. Number 9, the names, addresses, and telephone numbers of all witnesses the prosecution intends to call at any hearing or trial in this matter. Number 10, any and all factual statements of any individual interviewed by any person as part of this case. Such statements include all handwritten, written statements, notes, or a documentation of interviews, any statement summaries prepared by any interviewer, and any videotaped and audiotaped statements of any such person. Number 11, a complete criminal history of any person the prosecution intends to call as a witness at any hearing or trial. Number 12, full and complete Brady Giglio information regarding any person the prosecution intends to call as a witness at any hearing or trial. And just as a reminder, we learned about this, or we saw this in a few past cases, including most recently the Idaho 4 case, where Brady and Giglio refers to any evidence or any information that the state prosecution has that could find the defendant not guilty, or anything that could maybe make a witness statement or witness testimony not valid or not credible based on some information that they have. All right, number 13, copies of any and all photographs, videotapes, CDs, DVDs, or any other recording collected or produced by law enforcement and or the prosecution as a part of the investigation of the case. Moving along in this request for discovery, number 14, a list of exhibits the prosecution intends to offer at any hearing or trial in this matter. Number 15, copies of the hard drives of any computer or other electronic equipment, cell phones, etc., seized by law enforcement as part of the investigation of this case. 16, a complete copy of all reports and other documentation relating to any physical and or mental examinations performed on the defendant or any witness the prosecution intends to call at any hearing or trial in this matter. 17, a complete copy of all reports and other documentation relating to any scientific or medical examinations, experiments, or analysis performed as part of the investigation in this case, including any forensic analysis, scene reports, toxicology reports, and blood or breathalyzer tests. 18, the complete reports, tests, and complete files of any expert witness the prosecution intends to call at any trial or hearing. A, relatedly, the defense requests the underlying data, research, and information upon which the expert relied in forming his or her opinion. B, relatedly, the defense requests a disclosure of any exculpatory opinions of any expert witness with whom the prosecution may have consulted but does not intend to call as a witness. That's really interesting. That's interesting. Okay, number 19. The date, time, and contents of any out-of-court statements that may be offered under Utah Rule of Criminal Procedure 15.5, out-of-court statement and testimony of child victims or child witnesses of sexual or physical abuse, including the name and address of any witness through whom such statements will be offered. 20. Disclosure of all exculpatory information, whether written down or not, known by any member of the police, prosecution, investigation team. 21, a list of any evidence, including but not limited to any physical evidence, recordings, samples, records, and notes which have been misplaced, lost, or destroyed. 22, information or evidence known or information or evidence that becomes known to any member of the police, prosecution, investigation team that tends to negate or impeach the credibility of witness testimony or other evidence relied on by the prosecution. 23, all evidence which tends to mitigate the guilt of the defendant or mitigate the degree of punishment or potential restitution, including any factors set forth in Utah Code 76-5-406.5 or the current adult sentencing and release guidelines or similar sentencing guidelines. 24, notice of all evidence which the prosecution may rely on or present in any potential sentencing hearing in accordance with Utah Code 77-18-1. 25, the result of any polygraph examination, voice analysis, or any other like truth detection analysis. 26, the results of any scientific or medical testing performed on any evidence seized in the case, including any evidence obtained from the alleged victim or the defendant. 27, the name, address, and telephone number of all victim/witness counselors, caseworkers, therapists, or any persons who have obtained factual statements/information from any witness and or treated any alleged victim, whether reduced to writing or not. Okay, this one, I have some concerns with this, but hopefully they're only referring to factual information, not any type of, personal or protected conversations that the victim or witness would have with a therapist, right? Like, I don't want that information to be divulged if I'm going to a therapist. Anyway, 28, any evidence the prosecution has pursuant to Utah Rule of Evidence 404. Additionally, the defendant requests specific notice of any intent to introduce evidence under Rule 404 well enough in advance of trial in order to file any necessary motions in limine or otherwise be prepared to meet such evidence at trial. Okay, so I just wanted to confirm Rule 404 is character evidence, crimes, or other acts. Character evidence, prohibited uses, evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in conformity with the character or traits. 29, any and all evidence the prosecution has pursuant to Utah Rule of Evidence 608. Additionally, the defendant requests specific notice of any intent to introduce evidence under Rule 608 well enough in advance of trial in order to file any necessary motions or limine or otherwise prepared to meet such evidence at trial. So 608 has to do when photographs, fingerprints, or HIV infection tests may be taken. And I think in this case, it's particular here, it says here, the division shall take a photograph and fingerprints of a minor who is 14 years old or older at the time of the alleged commission of an offense. That would be a felony if the minor were 18 years old or older. So I think it has to do here with the age of when photographs, fingerprints, and HIV infections may be taken. 30. Any and all evidence the prosecution has pursuant to Utah Rule of Evidence 609. Additionally, the defendant requests specific notice of any intent to introduce evidence under Rule 609 well enough in advance of trial in order to file any necessary motions in limine or otherwise be prepared to meet such evidence at trial. Okay, and 609 has to do with failure to report threats and intimidation and penalty. A person is guilty of a Class B misdemeanor if the person willfully fails to report. Dated this 18th day of April 2023, respectfully submitted Kara M. Tangaro, attorney for defendant, and Scott Williams, attorney for defendant. Certificate of service, I hereby certify that the foregoing was delivered to the interested parties electronically via green filing system. Okay, so this was the original tweet from SF Investigates. Jared Leisek VP next hearing has been postponed until May 3rd by stipulation of all parties. Jared has replaced his attorney. Smart move. He now has 2 lawyers. This move proves Jared now understands he is in serious trouble in the case and facing a long prison sentence. His new lead attorney is Kara Tangaro, a Utah-based sex and violent crime defense attorney. She previously represented a Utah GOP activist who was charged with meeting women on a LDS church dating website and Ring them. Tangaro fought to get him out on bail. The court granted a $2 million bail, and once released, the man unalived himself. These delays and legal maneuvers are very common in cases preparing for trial. Jared Leisek lawyers also filed a request for discovery from the DA's office. Even though the same request was made by his original attorney, this is common since his new counsel, no assurance the original attorney actually received all discovery and evidence that the prosecution intends on using against Leisek. Personally, I think this is all good news and shows Jared knows he is going to trial for R of a child. Screenshots are attached. If you'd like to view the entire 6-page request for discovery, it can be viewed at this link, which is what I showed you. So yeah, I agree. I think that other attorney was kind of like the butt of jokes on a lot of my videos. So even though we want justice for the victim, also, you could tell in the last motion to dismiss when you read the document that basically recapped what happened in that last hearing, that whatever his arguments were, they were not getting through to the judge. And so arguments were not being made. It wasn't conveying the right arguments. So yeah, I can totally see why he let go of that attorney and got 2 new attorneys. So we shall see how that delays the case, how that, what happens now with the case. So let me just take one last thing. I'm going to look up this attorney. Tangaro Law, tough, fair, proven legal defense. She's your personal crisis manager, non-judgmental counsel, negotiator, and successful litigator. So let's look at about. Kara Tangaro is an experienced criminal defense attorney based in Utah. She has handled many felony jury trials, including capital homicide, a former prosecutor for the Salt Lake County District Attorney's Office. She is a tested, trusted defense attorney and uniquely suited to serve her clients as they navigate challenging cases. Okay, let's do a Google search and see if any news comes out about her. Bill that supporters say would fill gap for our victims in Utah law fails in committee. So it says here, while supporters say a defeated bill supported by Representative Angela Romero would fill a gap in Utah law that lets some sexual assault victims to fall through the cracks, opponents argue that it could have unintended consequences. Change is hard, Romero told committee members before they voted Monday, but sexual assault is underreported, under-investigated, under-prosecuted, and under-convicted in Utah and across the nation. Her bill is not going after that naive boy who some opponents of HB 78 said they worried would get swept up in her proposed change to Utah's criminal code. Rather, Romero said, we're going after that individual who knows what they're doing and they know how to manipulate the law. Kara Tangaro, who previously prosecuted sex crimes at the Salt Lake County District Attorney's Office, is now a defense attorney, said she opposed the bill partly because Utah's current criminal code already covers victims who are unconscious and can't give consent. Okay, so that would make sense as a defense attorney that she wouldn't want to have extra House bills related to consent. All right, so we already have Kara Tangaro is the attorney for Brent E. Taylor, the former director of the Utah Valley Youth Symphony. Judge declines to dismiss sex abuse case against ex-Youth Symphony director. Okay, so she defends a lot of sex abusers, it appears. I hope that justice is served in this case. What do you think? Let me know in the comments. And if you learned something, please hit the thumbs up and subscribe to my channel for more empowering true crime updates. Stay safe, stay thriving, and have an empowering week. Bye for now. Don't forget to like, subscribe, and hit the bell button for notifications. Thank you.